In a historic smackdown, a federal judge has obliterated Illinois' controversial gun ban, sending anti-gunner leftoids scrambling to pick up the pieces. This wasn't just a minor setback for the anti-gun crowd. It was a legal cannonball aimed squarely at the heart of the Protect Illinois Communities Act. For Second Amendment supporters, this is the kind of courtroom victory we've been waiting for. Bold, unapologetic, and rooted in the Constitution. The Protect Illinois Communities Act, touted as a solution to gun violence, did little more than strip law-abiding citizens of their rights, but the courts, as they should, called it out for what it is, a direct affront to the Second Amendment. This ruling doesn't just set a precedent for Illinois. It sends a clear message to every state that thinks they can sidestep the Constitution. In this video, we'll break down the details of this monumental ruling, what it means for gun owners in Illinois and beyond, and why this battle is far from over. Buckle up. It's going to be a good one. In January 2023, Illinois enacted the Protect Illinois Communities Act, aka PICA, a sweeping piece of legislation aimed at curbing gun violence through stringent restrictions on firearms. The law sought to ban over 170 semi-automatic weapons and high-capacity magazines, framing these measures as essential for public safety in the wake of mass shootings. The act specifically targeted a broad range of firearms, including popular models like the AR-15 and AK-47, as well as magazines capable of holding more than 10 rounds for long guns and more than 15 rounds for handguns. Violations of the act carried severe penalties, ranging from hefty fines to potential felony charges, depending on the nature of the offense. It's hardly surprising that Illinois, already infamous for being one of the most gun-restrictive states in the nation, decided to double down with the Protect Illinois Communities Act. Banning firearms like the AR-15 and AK-47, some of the most popular and widely owned rifles in America, along with so-called high-capacity magazines, is just par for the course in a state where lawful gun owners are treated like criminals. Meanwhile, the real criminals, they're running rampant, contributing to Illinois' dubious title of being a hotspot for gun-related crimes despite its draconian laws. This act takes the typical anti-gun narrative to new lows, targeting semi-automatic firearms like the AR-15 and AK-47, some of the most popular and widely owned rifles in the United States. These firearms, often demonized as weapons of war, are in reality semi-automatic rifles designed for civilian use. Unlike their military counterparts, they do not possess fully automatic firing capabilities. Let's talk about numbers. The AR-15 alone accounts for over 16 million firearms owned by law-abiding Americans as of 2023, making it one of the most common rifles in circulation. These are not niche weapons owned by fringe groups. They are mainstream tools for home defense, competitive shooting, and recreational use. A 2019 survey by the National Shooting Sports Foundation, or NSSF, revealed that 61% of AR-15 owners use their rifles for home defense, and another 35% use them for target shooting. Yet Illinois lawmakers decided to label these tools as threats to public safety, while ignoring that rifles of all types account for less than 3% of gun homicides annually, according to FBI crime data, and the so-called high-capacity magazines? They're standard. A 30-round magazine, for instance, is considered the norm for AR-15 US. Restricting such magazines doesn't deter crime. It limits responsible gun owners' ability to defend themselves effectively against multiple threats. Illinois legislators claim their restrictions on firearms and so-called high-capacity magazines will curb violence, but the reality couldn't be more different. Their laws don't stop criminals. Those who operate outside the law simply ignore them. Instead, these measures handicap law-abiding citizens who are already at a disadvantage when confronting violent threats. Think about it. An active shooter armed with an illegally sourced rifle and multiple 30-round magazines, opens fire in a crowded public space. His ability to inflict harm is limited only by how quickly he can reload. Now, imagine a legally armed citizen on site, carrying a heavily neutered AR-15 with a state-mandated 10-round magazine. When seconds matter, this citizen's chances of stopping the shooter are significantly diminished, not because they lack courage or skill, but because they are 20 bullets short. Studies have shown that the average law enforcement response time to an active shooter incident is between 3 and 11 minutes, depending on location. During those critical moments, a legally armed citizen is often the first and only line of defense. But with a 10-round magazine, their ability to neutralize a threat diminishes to non-existent levels. Every missed shot or every second spent reloading increases the risk to innocent lives, all because legislators thought less capacity equals more safety. Meanwhile, criminals face no such restrictions. They procure their weapons and accessories through black markets, theft, or straw purchases. Data from the Bureau of Justice Statistics reveals that 90% of criminals obtain firearms illegally. The only people Illinois' laws impact are those who follow them, law-abiding citizens who simply want the tools to defend themselves and others effectively. These restrictions aren't just misguided, they're dangerous. Illinois lawmakers are trading false optics of safety for real-world vulnerabilities, leaving good people defenseless when it matters most. Besides, this ban isn't about safety. It's about control. It's about stripping law-abiding Americans of their rights and their ability to protect themselves, their families, and their property. Illinois has chosen political theater over meaningful solutions, and as history shows, criminals won't follow the script. The penalties in Illinois' Protect Illinois Communities Act are nothing short of draconian, punishing law-abiding citizens for exercising their constitutional rights while doing nothing to address the real sources of gun violence. Fines and felony charges for merely owning commonly used firearms like AR-15s or standard capacity magazines don't deter crime. They target the wrong people entirely. Criminals, by definition, do not follow laws. They are not walking into gun stores to comply with background checks, registration requirements, or capacity limits. Illinois lawmakers know this, or at least they should. The real drivers of gun violence in Illinois are glaringly obvious. Chicago, for example, remains a hotspot for gang activity, which the National Gang Intelligence Center attributes to the city's persistent violent crime rates. Yet state legislators focus on regulating the tools of law-abiding citizens rather than addressing the root causes of violence like organized crime, illegal firearm trafficking, and the revolving door of the state's criminal justice system. The Illinois Sentencing Policy Advisory Council has repeatedly highlighted how recidivism rates remain alarmingly high due to lenient sentences for violent offenders. This legislative approach isn't just misguided, it's counterproductive. By turning ordinary citizens into criminals through overly broad restrictions and severe penalties, Illinois lawmakers alienate the very people who respect and follow the law. Instead of empowering residents to protect themselves, the state enforces measures that embolden criminals who know their victims are increasingly disarmed and vulnerable. The irony is stark. Illinois legislators claim to be addressing gun violence while ignoring its actual causes. This isn't about public safety. It's about control. Their policies erode the rights of law-abiding citizens while leaving violent offenders untouched. For a state that claims to be focused on public safety, Illinois is more concerned with making life miserable for responsible firearm owners than actually curbing violence. Perhaps it's easier to grandstand on banning scary-looking rifles than to tackle the hard truths about why crime continues to soar. The Protect Illinois Communities Act sparked fierce backlash, and rightly so. While gun control advocates predictably hailed it as a supposed solution to gun violence, claiming it would save lives by restricting access to high-capacity firearms, Their arguments were riddled with the same tired, baseless assumptions. Restricting law-abiding citizens doesn't prevent mass shootings or stop criminals who, by definition, don't follow laws. On the other side, our fellow patriots and pro-2A friends immediately saw the act for what it was, a blatant and unconstitutional power grab that punishes responsible citizens while doing nothing to address the real causes of gun violence. Instead of targeting issues like gang activity, illegal trafficking, or systemic failures in prosecuting violent offenders, Illinois lawmakers took the lazy route, attacking the rights of those who respect and uphold the law. This divisive legislation inevitably set the stage for a crucial legal showdown. Our friends swiftly challenged its constitutionality, understanding that this fight wasn't just about Illinois, but about stopping a dangerous precedent that could embolden other states to follow suit. Good thing that U.S. District Judge Stephen P. McGlynn declared in a landmark decision that Illinois' Protect Illinois Communities Act is unconstitutional, ruling that it infringes upon the Second Amendment rights of citizens. This decision arose from a consolidated lawsuit, Barnett v. Raoul, where plaintiffs challenged the sweeping firearm restrictions imposed by the state. The Protect Illinois Communities Act, enacted in January 2023, was introduced as a measure to enhance public safety. It banned the sale and possession of over 170 semi-automatic firearms, including widely owned models like the AR-15 and AK-47. High-capacity magazines exceeding 10 rounds for long guns and 15 rounds for handguns were also prohibited. Existing owners of these firearms were required to register them with the Illinois State Police. Penalties for non-compliance were severe, ranging from steep fines to felony charges. The lawsuit, filed by a coalition of Second Amendment advocacy groups, firearm dealers, and individual gun owners, targeted Illinois Attorney General Kwame Raoul and other state officials tasked with enforcing the act. The plaintiffs argued that PICA violated constitutional rights by banning firearms commonly used for lawful purposes, such as self-defense and hunting. They highlighted three key points. The act infringed upon the Second Amendment by targeting firearms in common use. It lacked historical precedent, as no tradition exists in the U.S. of banning commonly possessed firearms, and it was overly broad and vague, leading to potential arbitrary enforcement. Judge McGlynn sided with the plaintiffs in a detailed 168-page opinion. He emphasized that the government cannot strip law-abiding citizens of their right to self-defense. He stated, "The government may not deprive law-abiding citizens of their guaranteed right to self-defense as a means of offense." He also pointed out that the Act's broad scope infringed on the rights of tens of millions of lawful gun owners and lacked historical grounding. Acknowledging the gravity of his ruling, Judge McGlynn stayed its enforcement for 30 days to allow Illinois officials to appeal. Attorney General Kwame Raoul quickly filed a notice of appeal with the U.S. Court of Appeals for the Seventh Circuit, signaling the state's intent to defend the law based on public safety concerns. This decision carries implications far beyond Illinois. It challenges similar gun control laws across the country and sets a strong precedent for future Second Amendment cases. As this legal battle unfolds, the case underscores the judiciary's role in safeguarding constitutional freedoms against legislative overreach, ensuring that laws respect the foundational principles of individual liberty and justice. Second Amendment advocacy groups are celebrating this monumental victory. GOA proudly declared, quote, "We warned them to fall in line, but they chose to do the opposite." While this case took time, we are thrilled with the victory and for the citizens of Illinois. The Illinois State Rifle Association, or ISRA, also cheered the decision, showing their commitment to defending the rights of millions of Illinois gun owners. These groups have long argued that PICA was nothing more than a thinly veiled attack on law-abiding citizens, criminalizing commonly owned firearms and stripping individuals of their ability to defend themselves. On the other side, anti-gun advocates are clutching at straws. Governor J.B. Pritzker called the ruling a setback, claiming the act was meant to Protect Illinoisans from the constant fear of being gunned down. Attorney General Kwame Raoul's immediate appeal of the ruling signals that the state is more interested in preserving its anti-gun agenda than respecting constitutional freedoms. Media coverage has been predictably polarized. Pro-Second Amendment outlets have rightly framed the decision as a triumph for individual liberties and constitutional integrity, emphasizing Judge McGlynn's point that the government cannot strip law-abiding citizens of their rights under the guise of public safety. Meanwhile, left-leaning outlets focus on the usual fear-mongering, suggesting this ruling will lead to chaos, despite decades of data showing no correlation between stricter gun laws and reduced crime rates. This decision is more than a legal victory. It's a turning point in the fight to protect the Second Amendment. As Illinois scrambles to appeal, the nation watches, knowing that this battle will shape the future of firearm rights for millions of Americans. The Constitution is clear. The right to bear arms shall not be infringed. And that's it for this video. What do you think about this landmark decision? Share your thoughts in the comments, like this video, subscribe, and hit the bell icon for more updates on the fight to protect your rights.